case briefs, and so much more. LSData's got what you're looking for.
In 1998, the Supreme Court probe into corporate environmental liability took center stage with the case of United States v. Bestfoods. The case was brought under the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, CERCLA, which empowers the government to orchestrate and fund pollution remediation efforts using the Hazardous Substance Superfund. A key metric for responsibility is the term owner or operator, a label that under CERCLA has broad and inclusive implications, extending even to corporations. The crux of the matter revolved around whether a parent corporation, CPC, could be held accountable for environmental repercussions caused by its subsidiary, a chemical plant called Ott II. The parent company was sued by the United States government for the expenses associated with cleaning up industrial waste generated by Ott II. The question before the court was if CPC, despite being a parent company, had sufficient control over Ott II and actively participated in its operations to such a degree that it could be held liable for the pollution. The initial trial concluded that the corporate veil, the legal separation between a corporation and its owners, remained intact unless stark control was exercised by CPC. The interpretation suggested that a parent corporation like CPC would not be charged as an offender unless it directly participated in or held sway over the operations of the facility, therefore qualifying as an operator. In an interesting turn of events, the Supreme Court overruled the Sixth Circuit Court of Appeals' prior decision. The High Court commanded the case to return to the District Court, asking it to reevaluate the level of involvement of CPC's agents, including Williams, in the operations of Ott II. As per the Supreme Court's instructions, the District Court was directed to proceed with additional proceedings. This landmark decision underscored the necessity of assessing the relationship between a parent company and the facility in question, rather than simply examining the bond between parent and subsidiary.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind, leave the stress of class.